Hello, my name is Fabian Degen. I am the owner of FMD Wealth Advisors. This is my podcast, Don't Screw Up Divorce. I'm a certified financial planner, chartered financial analyst, enrolled agent with the IRS, certified divorce financial analyst, and certified quadro specialist. I help people that are going through major life transitions like divorce. I'm supporting my clients before, during, and after divorce, and I work with clients nationwide. If you would like my help, click the link in the show description or visit fmdwealth.com to schedule a call with me. We are open for business. Before we dive into this week's podcast, one important disclaimer at the beginning. We are not attorneys and we do not provide legal advice. Anything that is being said should not be considered legal advice by any means. Please consult with your attorney with regards to your legal questions. So, this week's podcast is focusing on the question, when can you change a custody order in New York? So, custody modification petitions are almost as common as original petitions. People are often establish custody when their children are relatively young, and as the children age or circumstances shift, the arrangement no longer fits. Sometimes the underlying conflict was never truly resolved and simply grows over time until one parent petitions for sole custody. Whatever the reason, New York courts apply a consistent framework to decide whether a modification is warranted, and it helps to understand that this framework is the first step to building or defending against a petition. So let's talk about the process. So first, the court asked whether there has been a change of circumstances since the last order was entered. Second, the petition must explain why the request change is in the best interest of the child. The real work lies in presenting evidence that ties the changed circumstances to the children's best interest. Common triggers, for example, include one parent moving far enough away to affect the other's access time, one parent withholding access, or a parent failing to properly care for the children. The analysis returns to the same factors used in the original custody determination, with an added focus on which of those factors have now changed. So let's talk about the factors the court weighs. Best interest in New York is driven by case law rather than a single statutory checklist. Among the sub-factors courts consider are the original placement of the child and how long that placement has lasted, the child's own desires, the relative fitness of each parent, the quality of each home environment, the guidance each parent provides, each parent's financial status, each parent's ability to support the child's emotional and intellectual development, and each parent's willingness to ensure a meaningful contact with the other parent. That last factor carries real weight. Withholding access is a key factor to consider. Another one is the non-custodial parent speaking badly about the custodial parent to the children. If such behavior does not stop, a court may consider restricting that parent's access. So, how can you prove a substantial change of circumstances? A change of circumstances is proven the same way an original custody determination is proven, with evidence. In high conflict situation especially, keep a very careful paper trail. If you are being denied access, document every missed or canceled visit, ideally through emails or text messages with the other parent. A judge will find it hard to believe that a parent never received any of the long series of messages. So co-parenting platforms can organize these communications even more effectively than scattered text or email chains. Capture your understanding of important discussions in writing and consider asking the other parent to correct the record if anything you have written is inaccurate. Let's talk about where you can file for modification of child custody. If the order came out of a Supreme Court divorce, you can usually choose to return to the Supreme Court or file in family court. In family court, you file a petition. In Supreme Court, you file an order to show cause, which typically needs to be drafted by an attorney. If custody or visitation is the only issue, family court is usually the better venue. But where custody is tangled together with child support and property distribution, you are generally better off in Supreme Court, where a single judge can address the intertwined issues together rather than splitting them across courts. So let's talk about how long it takes and what the risks are of filing. So timing varies widely. A determination can come on the first court date, or a contested case can require a full hearing or trial. A full-blown custody trial in the greater New York City area can last a year or more through only, and keep that in mind, about 5% of cases go all the way to trial. The vast majority resolves before that. So filing also carries risk. So if you petition, the other party may cross-petition and seek changes that benefit them. The court can consider both petitions, but you generally cannot end up worse off than you started on your own application unless the other party and the other parent cross-petitions. So if you do not prove your case, the usual remedy is simply dismissal. Where there is a wide income disparity, the more moneyed parent can also be ordered to pay the other parent's counsel fee. So let's say both parents agree to the modification. So an agreement between the parents does not guarantee approval. If the court believes a proposed resolution would put the child at risk of harm, it can order an investigation and report by the state agency charged with protecting children, so for example, child protection services, before deciding. Because child decisions ripple into child support, the marital residence, and each household's budget, it is worth modeling the financial side with a trusted, certified divorce financial analyst before you finalize an agreement. A parenting plan that looks fine on paper can strain your finances if the numbers were never run. So coordination between your legal and financial team helps you sign an agreement your budget can actually sustain. Let's talk about the evidence that carries weight in the child custody modification process. Because the best interest is proven with evidence, the quality of your proof matters as much as your argument. If you allege abuse or neglect, you must show actual evidence of it. For example, a doctor's report or a child's disclosure to a teacher, guidance counselor, or therapist can be brought into the case. So evidence also takes the form of testimony from the parties and their witnesses, along with videos, audio recording, emails, text, social media posts, and photographs. Experts, witnesses can also play a role. So the parent who arrives with an organized, documented records is in far stronger position than one relying on statements without documentation. Custody decisions are usually framed as purely emotional or legal, but they also have a financial spine running through them. So whoever parent ends up with the primary resident custody, it will shape the child support, the fate of the marital home, the tax filing status, and which household carries which expenses for years. For that reason, the parent who came through a modification in the strongest position tend to be the ones who build a team rather than relying on an attorney alone. Your attorney handles the law and the best interest case. A CDFA, Certified Divorce Financial Analyst, can model what each proposed parenting arrangement does to your long-term cash flow, retirement trajectory, and ability to support the children at the standard everyone wants to maintain. So, running those numbers before you agree to anything and revisiting them whenever circumstances change is how you make sure the arrangement you fight for is the one you can actually afford to live with. So let's talk why specialized counsel matters in this case. So an attorney is strictly not required for custody modification, but it is almost always beneficial, and the choice of attorney matters as much as the decisions to hire one. If the other side has counsel, you want counsel too. And in New York, if you cannot afford an attorney for custody matter, you may qualify for a court-assigned counsel, so there's rarely a good reason to face such an important issue alone. Just as important is choosing someone who concentrates in family law, a lawyer who handles whatever comes through the door, as the saying goes, a jack of all trades and a master of none. When you have a serious custody matter, you want a specialist, the same way you would see a specialist rather than a general practitioner for a serious medical issue. So one practical test is to ask what share of the attorney practice is devoted to divorce and family law. If the answer is not the clear majority, keep looking. So pair that specialized legal judgment with a certified divorce financial analyst who can quantify what each custody scenario means for support, taxes, and your household budget, and you give yourself the strongest possible footing. A team that protects both your relationship with your children and the financial stability that this relationship depends on. So let's go through some frequently asked questions that we receive from clients. Will the judge automatically approve a change we both agree to? Well, no, not automatically. Even when both parents agree, the court does not have to sign it off. If it perceives that the resolution could put the child at risk of harm, it can order an investigation and report the case to CPS, Child Protection Services, to weigh in before a decision is made. Next question. Could the other parent end up with custody just because I filed? Only if they file their own cross petition. A court can consider both petitions, but you generally cannot end up worse off than when you started on your own application unless the other parent cross petitions. If you do not prove your case, the usual remedy is that your application is dismissed. Next question. How is the best interest of the child defined? Well, there is no single statutory definition. It is case law driven. Courts weigh factors such as child age and preference, any abuse or neglect, interference with either parent's relationship, the quality of each home, each parent's finances, and importantly, each parent's willingness to encourage a relationship with the other parent. Do I need an attorney for custody modification? Is one of the questions we receive. It is almost always beneficial. If the other side has counsel, you want to counsel as well. In New York, if you cannot afford an attorney for custody matters, you may qualify for court-assigned counsel. So there's rarely a good reason to face such an important issue unrepresented. This was this week's podcast. Don't screw up divorce. My name is Fabian Degen. I'm the owner of FMD Wealth Advisors. I'm a certified financial planner, chartered financial analyst, enrolled agent with the IRS, certified divorce financial analyst, and certified Quattro specialist. I help people that are going through major life transitions like divorce. I'm supporting my clients before, during, after the divorce, and I work with clients nationwide. If you would like my help, click the link in the show description or visit fmdwealth.com to schedule a call with me. We are open for business.